Yes.
Good morning, members of Parliament, support staff, radio listeners, TV viewers, those viewing via social media, and members of the media. Welcome to this Central Committee meeting number 27 of today, Wednesday, April 20th, 2021. I would like to give a 2022, went a year backwards. I would like to give a special welcome to Professor Gerhard Hochers. And we have established a quorum of 5 members and 4 factions. Please let's stand for a moment of silence. I've received notice of absence from MP William Marlin and notice of lateness from MP Sarah Westcott, MP De Weaver, MP Ponteflet, and MP Duncan. Is there any member of Parliament who wishes to have the floor for notifications? Oh, and also a notice of lateness for MP Peterson. And I see there's no need for notifications. So with that, then we go over straight to the agenda point. We have as agenda point for this meeting, presentation by experts regarding the pros and cons of the draft consensus Kingdom Law Caribbean Reform and Development Agency. This can be found under IS 547, Parliamentary Year 2021-22, dated February 11, 2022. Parliament received the draft Kingdom Law Caribbean Reform and Development Agency on February 11, 2022. This document is registered, as stated before, under IS 547 and can be found on the P drive. The Committee of Kingdom Affairs and Interparliamentary Relations decided in its meeting of March 16, 2022, to invite the Prime Minister to a closed-door technical briefing, which would be followed by a Central Committee meeting with the Prime Minister regarding the COHO. These 2 meetings have already been held. The CCARE Committee has also proposed a list of experts to be invited to give their take on the pros and cons of the draft COHO Kingdom Law in a Central Committee meeting, hence today's meeting. So it is good to know that today's meeting is the first of said meetings and the first of many more to come. Upon the invitation from Parliament, Professor Gerhard Hochers is here to present his take regarding the pros and the cons of the draft consensus Kingdom Law COHO as presented by the Kingdom Government. At this time, I would like to give the floor over to Professor Hochers for his opening remarks and his presentation. Professor Hochers, you have the floor.
Thank you, Madam Chair. Yes, good to be back again after so many hours. First of all, before I start, I realized, and I thought of that before I left the Netherlands, but in all the buzz since, I've forgotten to come back to it. I wasn't able to make a print of the actual text of the law proposal as it is momentarily. So I don't have that. I know roughly what stands where, but it would perhaps be good if I could have a paper copy of the text of the draft.
Would you like me to adjourn the meeting to have the text before your presentation?
If that is doable within 5 minutes or so, and I think it is, that would be good, yes.
I'll take a 3-minute adjournment. Meeting adjourned for 3 minutes.
Thank you.
Welcome back, members of parliament. We just took a brief adjournment to allow Professor Hochers some time to get the draft law in front of him. Professor Hochers, I give you the floor.
Again, thank you very much, Madam Chair. Yes, today we are dealing with the proposed Kingdom Act, Act of the Realm. I'm never quite sure what term to use in English, but de Rijkswet, COHO, Caribisch Orgaan Hervorming en Ontwikkeling. We will, of course, converse in English, but I think it will be almost impossible to avoid using Dutch terms sometimes because, well, the law is in Dutch. So it's the text of the law is in Dutch. Everything else related to it's in Dutch. So more than yesterday, I fear I will sometimes have to revert to Dutch, especially when it comes to technical terms. And I hope you will forgive me for doing that in your esteemed Parliament House. And if not, well, it can't entirely be helped, I think. The proposal we have in front of us now is actually the fourth incarnation, I think, of this draft law that started out in 2020, in August 2020 originally, as the proposed Rijkswet CHE Caribische Hervormingsentiteit. So this was originally meant as an entity to, bring about the reform of Caribbean economies, societies, governments. It wasn't entirely clear. It was simply a hervormingsentiteit. And what the reforms were about, well, that could be quite broad, and originally it was envisioned as being quite broad. Then critique came, especially from the overseas countries, which led to certain adaptations and a change of name into de Rijkswet Caribisch Orgaan voor Hervorming en Ontwikkeling. So no longer an entity, an entiteit, but an orgaan, organ. And I will come back to that, to what that means, these different terms used for the entity we're discussing. And that name, the name COHO, stuck until now. There have been, I remember last summer, the summer of last year, I wrote an advice for the Curaçao negotiating team, the end phase of the then draft, in which they contacted me and said, look, The Hague is looking for a new name. Do you have any suggestions? I didn't, so I couldn't come up with anything better or less lame than COHO. So COHO, it has remained, and probably the entity, once it would come into reality, would be named COHO. So we're dealing with the Caribische Orgaan voor Hervorming en Ontwikkeling. That name sort of suggests that we're dealing with a Caribbean organ, which would quite strongly suggest that this entity is going to be an entity under the laws of Aruba, Curaçao, and Sint Maarten. And it's not. It's a Dutch entity, which is made clear in the Act. Article 2 of the draft now says, under 1, is een Caribisch orgaan voor hervorming en ontwikkeling, which is a phrasing quite often used in Dutch laws to simply state in an act the bringing into existence of something. Is een, like the charter says, is een Raad van State van het Koninkrijk. It's not a phrase that is very swift or fluently translatable into English. In Dutch it sounds better, and it's quite often used. So this simply means that the COHO is brought into existence. Het COHO is gevestigd in Den Haag. It is, set up in The Hague. The Act no longer says in so many words that this is an entity under Dutch law or anything, but it's quite obvious that it is, because it is situated in The Hague, and certain articles, and we will come back to that, of the Kaderwet bestuursorganen are applicable to the COHO, which really also only makes sense, actually, if it is a Dutch organ. Now, there have been quite a few ideas passing along about what this entity should be like, originally it was envisioned as a rechtspersoon. So a separate legal entity under Dutch law. That was the idea originally. And that was powered, this idea, by the fact that originally the law proposal contained provisions that would allow the coho to enter into transactions under private law. For instance, buy stuff, sell stuff, go into negotiations with private contractors and things like that. And in order to be able to do that, it should have and personality under private law, because otherwise you cannot act under civil law. So, but the interesting thing is that this was to be an entity under Dutch private law, which is so a rechtspersoon under Dutch law, legal person under Dutch law, which is quite peculiar. And I remember when I saw the first draft and I read the Memorie van Toelichting, that did not really explain. I mean, it explained why legal personality was needed, but it did not explain why that legal personality should be a legal personality under Dutch law, according to the Dutch Civil Code. Because there are, obviously, precedents where legal persons are brought into existence under kingdom law. I mean, a very clear example of that is the CFD, which is a legal person, but not under the laws of the Netherlands, but on the basis of the act itself, or perhaps even more enlightening, the Gemeenschappelijke Hof van Justitie, which is also a legal person based upon the Kingdom Act itself. So there are clear precedents that the Kingdom legislator can create a legal person itself, which is not a legal person under Dutch, Aruban, Curaçao, or St. Martin law, but a legal person sui generis, you might say, under the act itself. And it was never clear why the legislator here, why the government here decided that this legal person should be a legal person under Dutch civil law. But anyway, that idea has been skipped and was then replaced by the idea that no, the coho should not be a legal person under Dutch law, it should be a zelfstandig bestuursorgaan. But still a zelfstandig bestuursorgaan under Dutch law. But not entirely like ordinary Dutch zelfstandige bestuursorganen, because the kaderwet zelfstandige bestuursorganen was not entirely applicable. That was never envisioned that the whole of that act should be applicable, only certain articles enumerated in the Rijkswet Coho itself. And that idea was also skipped. And in this latest incarnation, the coho is een bestuursorgaan, but not a zelfstandig bestuursorgaan. It is, let alone een zelfstandig bestuursorgaan with legal personality, it is simply, we have to assume, an organ of the Netherlands, of the Dutch state. Like we have others in the Netherlands that don't have separate legal personality, but are, sort of separate organs of the central Dutch state, het Rijk, as we say in the Netherlands. So that is presumably the status that coho is supposed to have. It has a certain independence, but it is an organ of the state of the Netherlands. Or, if you will, in statutory terms, in charter terms, the country of the Netherlands. Which, again, sort of suggests that the term Caribisch orgaan is a bit misleading. It is actually a Dutch orgaan that is going to be active in the Caribbean, but that's something else, of course. So that's the organ as it's, the authority as it is supposed to come into existence. Originally, it was also envisioned that this coho would get very far-reaching powers. Some of them, and the Raad van State, the Council of State gave, and I would say very correctly, gave severe criticism on certain of these provisions in its advice that was published in March 2021. And bear in mind, that critique was leveled against a law proposal that had already been amended, that had already been made less severe than it was originally. There were already had been made some changes to answer to critique coming from the Caribbean governments. But even this law proposal met severe criticism of the Council of State and also of the Councils of Advice, especially of Curaçao and Aruba, which sometimes went parallel with that of the Council of State and in some aspects was a little separate from it. But generally speaking, the advices of the Councils of Advice of Aruba and Curaçao and the Council of State, the Kingdom went in the same direction. The proposal as it was took away far too much autonomy from the Caribbean governments and parliaments. The division of powers between the governments and the parliaments and the COHO was very unclear. The division of power between the CFT and the COHO was very unclear. And there was a serious lack of legal protection against the measures that the COHO could take. The Kingdom government took that critique quite seriously and came up with a new proposal, and that's the one that's lying in front of us today. And I have to say, and that would then be sort of my opening remark on what we have in front of us, I think that it's far from a perfect instrument we have in front of us, but I think that a lot of the most severe disadvantages that were in the original law are no longer there. Generally speaking, a lot of the critique that was very justly founded by the Caribbean governments and parliaments against what was proposed have been met. Not all, and there are certain problematic points still left, I would argue, but a lot has been corrected. This, what we have in front of us, I would say, is a far better draft law than the one we had 2 years ago or even 1 year ago. So, what is different? Well, and I sent Garrick last night a short notice that I wrote it for myself actually last week. So let's see what is different now. But I thought what might be good to send it to Garrick so he could send it to all of you. One of the things that was quite striking in the law proposal, both for the original envisioned CHA as for the original COHO as it was envisioned in the summer of 21, was the power of the so-called verzwaard financieel toezicht. Something that I translated as enhanced financial oversight. So that might be a translation that might at least bring over what was supposed to be verzwaard financieel toezicht. This was a structure in which either the COHO or the Dutch Minister of the Interior, we will get back to his position too, because there is an interesting position, interesting role for the Dutch Minister of the Interior and Kingdom Affairs in this law proposal. Either the COHO or the Dutch Minister for the Interior, when either of them considered considered Aruba, Curaçao, St. Martin to be lacking in fulfilling the obligations that any of them had undertaken under the Landspakketten, and I'm sure we'll talk about the Landspakketten, but in my presentation I focus on the act itself. Any of the obligations from the Landspakketten, if a government or the authorities of one of the countries would not fulfill these obligations in the eyes of COHO or the Minister of the Interior, either of them could instruct the College Financieel Toezicht to enact enhanced financial oversight. So it was not a power of COHO itself to do that, but they could instruct the CFT to introduce enhanced financial oversight, and that could be more or less severe. The strictest form of it would have meant that basically the governments of Aruba, Curacao, St. Martin could not spend any money without first having permission from the CFT to do that. This was a very far-reaching power for a non-democratically elected, appointed committee, essentially, like COHO. It was also the only power that COHO would have gotten against which there was actually some form of legal protection in the Act. The COHO Act envisioned that either of the governments could, against this decision, bring about a form of kroonberoep, appeal to the Crown, akin to the one envisioned in, or the one regulated in the Rijkswet CFT. Very comparable to that. But that was the only power against which such a power of appeal was granted in the Act. All other decisions, and they could also be quite far-reaching, there were a number of other powers that the COHO would have gotten, were non-appealable. So, basically, yeah, sorry, you have to live with it. This was one of the sticking points for the Council of State, in which the Council of State said, look, the whole point of the Rijkswet CFT is that the College Financieel Toezicht is independent. Now, if either the Dutch Minister of the Interior or the COHO can instruct the CFT to do something, how can you still say then that the College Financieel Toezicht is independent? This must by necessity mean that the College Financieel Toezicht is no longer independent. But that can't be because the Rijkswet CFT says so. So the government must explain how it envisions the relationship between the COHO and the Minister of the Interior and the College Financieel Toezicht as an independent organ, because based on this act, that's no longer possible. And I think that, I assume I had some contact with civil servants in this phase of the, but I think they simply did not think about this when they proposed and when this critique came, and I think that shows because they haven't come up with any solution apart from just striking the whole power. It has been removed from the Act, no longer there. So neither the Minister of the Interior nor the COHO can enact such a thing anymore. As I still wrote here, something akin to it might reappear in the Act of the Realm on the CFT, but that is subject to negotiations. There is, in this note of wijziging, to which there is now, but I hadn't seen that yet because the advice was not public yet, but there is now the proposal for the amendments to the Rijkswet Financieel Toezicht to regulate how the CFT is supposed to be able to do something like it. But I haven't seen this yet. This is the first time I see it. So I haven't studied it yet, so I cannot really, comment too far on it about what this is. But this is the replacement, if you will, which is to be regulated not in the Rijkswet COHO, but in the Rijkswet CFT, where it should belong if you want it. Yes, please switch. Yes. There were quite a few instances in which the Dutch Minister of the Interior, and I constantly say the Dutch Minister of the Interior, this matters. Because, well, as you know, the whole structure of the Charter assumes that all of the ministers of the Netherlands are also a member of the Council of Ministers of the Kingdom, which arguably leads to the conclusion that you could say that all the Dutch ministers are also ministers of the Kingdom. In earlier times, the legislature used to be more precise in its wordings because always when a Dutch minister actually acted in a capacity as kingdom minister, the law would say so. It would say something like, onze minister van, now fill in the portfolio, van het koninkrijk, of the kingdom. That was never done, or almost never done, with the ministers of defense and foreign affairs, because they are solely kingdom ministers, so that doesn't make sense. There is no Minister of Defense of the Netherlands. There is only a Minister of Defense of the Kingdom, because defense is solely a kingdom affair. So, but that difference was usually made. Onze minister van Defensie en onze minister van Justitie van het Koninkrijk. Because that would then make clear that the Minister of Justice acted in his capacity as kingdom minister. But here, you see that in this law proposal, the Minister of the Interior is constantly referred to as the Minister of the Interior of the Netherlands. He could act in his capacity as Dutch minister, not kingdom minister. Which matters because you could argue, well, what does it matter? Well, it matters because when a Dutch minister acts in his capacity as kingdom minister, he acts also as a member of the Council of Ministers of the Kingdom, so together with the ministers plenipotentiary of the 3 Caribbean countries, with the according powers that the Charter grants these ministers to influence decision-making. Whereas, of course, when a Dutch minister acts in his capacity of Minister of the Netherlands, he acts together with his colleagues of the Council of Ministers of the Netherlands. And in quite a few instances in this original law proposal, the Minister of the Interior had the power to decide certain things relating to Aruba, Curaçao, St. Martin, and sometimes he could do that by himself. Well, actually it is a she now, but you know, let's stick to the legal fiction that a minister is always a he. Yeah, because always I constantly have to say he or she or well. You know what I'm talking about, you know. This, the Constitution always says we have a king, even it's a queen, so, well. So the Minister of the Interior sometimes could do certain things, could take certain decisions by himself, and sometimes only after consultation with the Dutch Council of Ministers. And I think that was put in the proposal very, very bedoeld. How do you say it in English? Intentionally, thank you, yes, intentionally. You see, same as I said yesterday, sometimes a word just doesn't come up soon enough. Yes, intentionally, thank you. That was put in intentionally, precisely because it was meant to be a consultation only with the Dutch colleagues and not with the colleagues of the 3 Caribbean countries, which is quite shrill in my opinion. So, I mean, in the comments I wrote last year on the Rijkswet Code, these were a few of the points that I criticized most heavily, because I argued you just can't, this can't be, you can't do this. Almost all of these provisions, and especially the construction where the Minister of the Interior could take decisions after consultation with the Dutch Council of Ministers, all of these provisions, there were 5 or 6 of them, have been struck, have been removed from the Act. There are basically 2 remaining powers of the Minister of the Interior in his capacity as Minister of the Netherlands. The justification for this is, of course, found, you can see that in the Mooi van Toelichting as well, is found in the idea that COHO is a Dutch organ. So then the minister can act in his capacity as Minister of the Netherlands and not Minister of the Kingdom. So one of the things that might still be, you know, worth pursuing is try and get this changed, come with amendments, perhaps during the behandeling in The Hague, come with amendments proposing to change the status of the COHO to not a Dutch organ, but perhaps a legal person in its own right under the Kingdom Act itself, because then that would automatically, that must by necessity lead to a situation where the Minister of the Interior cannot act in his capacity as Dutch minister, but must act in his capacity as Kingdom minister. So that means also with consultation powers for the rest of the Council of Ministers of the Kingdom. So that might still be something to take in, to keep in mind for the handling of the law proposal in The Hague in, well, June. It's probably going to be, right? Something like that. Yeah. Well, 2 interesting powers of the Minister of the Interior remain. One of them is set down in Article 6. It's a new one. It wasn't in the original proposal because there were so many others. And that's the one where it says in... Oh, yes. Please remind me, Madam Chair, to come back to Article 4 in a few minutes. Otherwise, I might forget it. Article 6 of the proposed law states in under 1... Het COHO en de minister van Algemene Zaken van het land stellen ter verwezenlijking van het landspakket periodiek een uitvoeringsagenda vast. De afspraken over resultaten in een uitvoeringsagenda vormen de basis waarop het COHO de voortgang, bedoeld in artikel 4, eerste lid onder B, beoordeelt. So, COHO and the Minister of General Affairs, well, the Prime Minister of each of the three countries, together must come to an agreement on how the landspakketten are to be enacted. You know, the so-called uitvoeringsagenda, which is basically nothing else than, you know, making, together come to agreements on how you're going to do it. Een uitvoeringsagenda bevat in ieder geval de projecten, programma's en maatregelen die vereist zijn voor het bereiken van de strategische beleidsdoelen genoemd in een landspakket onder vermelding van prioriteringen en resultaten in de vorm van prestatieindicatoren. I so love civil servant Dutch. Prestatieindicatoren. Well, I would never come up with a term like that. But anyway, so this is basically what this uitvoeringsagenda is about. It contains, well, the agreed projects, the programs, the measurements that the country wants to take to fulfill what? Well, first of all, it's quite broad. Strategische beleidsdoelen. So what do you want to achieve as a country? You know, I don't know, getting financial stability within 5 years, or, you know, things like that, diminishing the number of civil servants with 10%, whatever you have agreed with the Netherlands in the landspakket, how you're going to do that, how you're going to achieve your strategic aims. And then 3 is new, because one of the heavily, and I would say very justified, one of the serious points of critique of the Council of State was the law almost doesn't acknowledge the central fact that Sint Maarten isn't Curaçao. These landspakketten, these uitvoeringsagendas won't be the same. So you should differentiate. Now that's now in Article 6 under 3, which is a new lid. Een uitvoeringsagenda houdt rekening met de specifieke omstandigheden van een land. So, you know, this uitvoeringsagenda should take into account specific circumstances concerning Sint Maarten as opposed to Aruba or Curaçao or the other way around. And then we come to under 4. Onze minister, which is the Minister for the Interior, onze minister kan, na overleg met de minister van Algemene Zaken die het aangaat, het COHO een aanwijzing geven met betrekking tot de inbreng van het COHO in een vast te stellen uitvoeringsagenda. So what does this say? And this, like I said, this is new. Like 3, 4 is also new. This is the power of the Minister of the Interior to give instructions to the COHO about what COHO should bring to the negotiating table with the government of the country. The minister can only do that, can only give such an instruction, after consulting with the Prime Minister of the country. Now, this consult is not consent, right? You should notice the difference. Yes. There is consultation. There is not the necessity of consent. But there is consultation. So the Minister of General Affairs can, you know, bring his or her opinion to the table. Interesting is what the government has answered to the Council of State in its naderverslag. There the government says, this is not a political power for the Ministry of the Interior. This is not meant as a power where the Ministry of the Interior can give, you know, basically any instructions he likes, and COHO must fulfill that. This is meant, and again, this is what the government claims, the Kingdom government, in its reaction to the Council of State. This is meant as a power for the minister to adjust COHO if, according to the minister and the Minister of General Affairs of the country involved, COHO starts drifting from what the Dutch government and the government of the country have agreed upon. Because COHO is relatively independent. is meant to be relatively independent. So, the kingdom government claims, at least claims, that the Dutch Minister of the Interior can use this power basically only not to instruct Coho to put it roughly, to annoy St. Maarten, but can basically only use this power for the benefit of St. Maarten. If Coho, being the rather independent body that it is, would start deviating from what the Netherlands and St. Maarten have agreed upon, then, after consultation with the Prime Minister, the Dutch Minister of the Interior can give instructions to Coho how it should behave to prevent that from happening. Is that believable? Well, that's up to you. Yes. But, I mean, given Dutch political culture, such a public statement of the government in a document that is sent to the Second Chamber in a reaction to the Council of State, that means something. So I personally would think, and I think that you will hear that in the technical briefing that is going to be given on the IPCO, I think that the civil service of the Ministry of the Interior will say the same thing. You, at least according to the Dutch government, you should not look at this as a threat. You should basically look at this as sort of a, perhaps I'm exaggerating a bit now, but it's mostly meant as a stick for St. Maarten, not against St. Maarten. It's a stick against Coho, not a stick against St. Maarten. Now, and again, how believable that is, that's up to you. That's a political decision you will have to take. But this is at least what the government of the Netherlands claims to be the case. No, that's not true. But the kingdom government claims to be the case, because obviously the Rijkswet Coho is a law proposal from the kingdom government. But it's a claim of the kingdom government about the Dutch Minister of the Interior, who happens, of course, to be a member of the kingdom government. So that's an interesting and arguably problematic, but arguably also a beneficial power of the Minister of the Interior laid down in Article 6. The other one, and that one, and I did not forget Article 4. So we'll get back to that. Sorry? Yeah. The other one is Article 22. And this one is formulated a tad deviously, I must say. Yes. Because what the article says is the following. Als een land zijn verplichtingen krachtens deze Rijkswet nakomt, stelt onze minister, again, which is the Minister of the Interior, in overeenstemming met de Raad van Ministers van het Koninkrijk, periodiek financiële middelen ter beschikking. Deze financiële middelen kunnen onder meer worden verstrekt in de vorm van liquiditeitssteun, financiering van werkzaamheden. So this article says, if a country fulfills its obligations, well, then the Minister of the Interior must give money. Of course, this is in itself important. This shows that it's no longer, it cannot be the case that when St. Maarten objectively fulfills its obligations, then the Minister of the Interior can say, nah, you're still not getting any money. I mean, that's not possible. If obligations are met, money must be provided. En nummer 2, it says then, de beoordeling van onze minister of een land zijn verplichtingen als bedoeld in het eerste lid nakomt, geschiet op basis van de uitvoeringsrapportage bedoeld in artikel 21 eerste lid. Artikel 21 eerste lid says, het COHO verstrekt ieder half jaar en zo nodig tussentijds, al dan niet op verzoek van onze minister, een uitvoeringsrapportage over de uitvoering van de verplichtingen die bij of krachtens deze wet op de landen rusten, aan onze minister en in afschrift aan de minister van Algemene Zaken van elk der landen. In ieder geval bevat een uitvoeringsrapportage beoordeling van de voortgang van de uitvoeringsagenda. So every 6 months or more frequently if so wished, COHO gives an uitvoeringsrapportage, which basically contains how you say that, beoordeling, an opinion. Well, it's not binding, so it's an opinion of Coho on whether the country fulfills its obligations. And that opinion does or should not fall out of the blue air, out of the blue sky. It should be based upon the objective agreements laid down in die uitvoeringsagenda. Voordat een uitvoeringsrapportage wordt verstrekt, stelt het COHO onze minister van Algemene Zaken van de landen in de gelegenheid een zienswijze naar voren te brengen. Een zienswijze en een reactie daarop van het COHO worden in een bijlage bij de uitvoeringsrapportage meegezonden. So before COHO makes this uitvoeringsrapportage, it asks the prime ministers of each of the country to give their zienswijze, their opinion. And that opinion should be sent along with the uitvoeringsrapportage itself and with COHO's reaction to the Minister of the Interior. So the Minister of the Interior has to decide, based upon this objective uitvoeringsrapportage, the zienswijze van de Prime Minister and the reaction to that zienswijze van the COHO itself. And like I said, the article is formulated in positive terms. If a country fulfills its obligations, well, then it gets money. The article itself nowhere says what happens if that's not the case. No, that's only in de motie van toelichting. There, the motie van toelichting, the legislator, the kingdom government says, of course it's possible that, a country does not fulfill its obligations. And if that's the case, then, well, then the minister shall not give money. That decision is not appealable. I have a slight, I don't know. Sorry about that. Probably the air's a bit dry here as well. And that's, of course, very interesting. Now, obviously, I mean, this is sort of objectified. Like I said, it's not a pure political decision by the Ministry of the Interior based upon this uitvoeringsrapportage, all fine and good. But of course, that means that in the end, the minister has to make a decision based upon the documents in front of him, and the decision can be, you did not fulfill your obligations. That cannot be appealed. Well, yeah, the motie van toelichting says, Article 12, of course. Yes, of course, because it's a decision by the Kingdom Council of Ministers. So, gee, internal appeal. Well, you all know how wonderful that is, right? Internal appeal, yeah. So that really doesn't mean that much, and it means that this important decision is a decision that leaves you kind of without weapons. This, to me, is one of the two most serious remaining sticking points in the law as is today. I mean, I don't mean that sticking point as you shouldn't accept it. I mean sticking point in the sense that this is still, I would argue, a quite serious limitation on the autonomy, especially on the financial autonomy of the Caribbean countries. That does, of course, not mean that you shouldn't accept it, because there can be very good other reasons to do it nonetheless, but it is an important, this is, I would argue, an important limitation on the financial autonomy of Aruba, Curacao, and St. Martin. And it's problematic, I would say, that this decision is non-appealable. If that's truly the case, by the way, we will look into later on. But the Act at least suggests that this is non-appealable. So, Article 4, yes. We shouldn't forget it. Article 4 is it's not a very exciting article, but under 2, there is still a provision in it that has been in the law proposal since the beginning. And the Council of State says this provision doesn't make any sense. And still the government refused to take it out. Because it says, bij de uitoefening van de taken bedoeld in het eerste lid, kan het COHO geen bevoegdheden uitoefenen die op grond van het landsrecht van een land aan een overheidsorgaan van het land toekomen. This has been brought into the law proposal. It wasn't in the very first original draft. It was put in it because of criticism from the Caribbean countries. And it is meant as a tap on the shoulder, don't worry. Because this says the COHO can't enact any powers that under the constitutional law of the country are powers of the organs of that country. Now, and very rightly so, I would assume, the Council of State has said, okay, this means either of two things. Or, if you read this literally, Coho does not have any powers. Because, well, everything Coho does, it does under the constitutional law of the countries. Because it enters into the legal order of the Caribbean countries. That, if that reading is correct, the Council of State says this provision doesn't make any sense. Because you then would have to assume that this whole act that gives Coho all kinds of sometimes far-reaching powers doesn't mean anything. Or the power that Coho has under this act are real powers. They are real legal powers. But if that's the case, this provision also makes no sense, because then it's not true. Of course, Coho will have powers that are, under the constitutional law of the countries, powers of the constitutional organs of that country. So, either way, the Council of State argues, this provision is senseless. It doesn't make any legal sense, no matter how you read it. Now, if I would have been the kingdom government and I would have gotten that kind of critique, I would have taken it out. But it's still there. Because the government says, yeah, no, we don't want to remove it because, you know, we want to make clear that really we don't, it's now apparently meant as something basically symbolic or something like that. You know, we're trying to do as less as possible, something like that. But it's still, from a legal point of view, it's a provision that doesn't make any sense. My suggestion to you would be amend this out in the second chamber, because I think there is a lot of support. I could imagine there's a lot of support in the second chamber to get this out, because this is a nonsense article. Well, not the whole article, but the second clause of it is basically rubbish. So get it removed, I would say. Right. Yes. The Council of State paid a lot of attention, and rightly so, I would say, to the question, is this proposed act in accordance with the Charter? And they, well, they're also a political organ, of course, so they did not go as far as saying, no, this act is not in accordance with the Charter. But they did say that there were very serious tensions with the Charter, which is a polite political way of basically saying the same thing, of course. I, not being a politician and being an independent scientist, don't have that limitations put upon me, so I have argued last year that there was at least one provision in the Rijkswet Coho that was in clear violation of the Charter. That was the proposed Article 26. In which the Coho would have gotten the power to enter into financial agreements with international organizations and the European Union, you know, basically out of its own accord. And the Council of State, very rightly so, said, yeah, strictly speaking, of course, these are then, you know, agreements made between Coho and an external international partner. Yes, strictly speaking, the country is not a part of those agreements. But materially speaking, of course they are. I mean, if Coho enters into binding agreements with, let's say, the World Bank, of course that matters to St. Maarten, even if St. Maarten is officially not a partner in that agreement. So the Council of State says, apparently, no attention has been paid to Article 26 of the Charter, which obviously very clearly states that Aruba, Curacao, St. Maarten cannot be bound by any financial agreements without their consent. I fear that this again is simply an oversight. I fear that the civil servants writing the draft did not think of this. And so the article criticized by the Council of State has been amended. It now says, and I think that is an adequate adjustment, It now says that Coho can only enter into such an agreement after consent of the Prime Minister of the country involved. Not consult, consent. The agreement, the country government must agree to such a proposed agreement of Coho with a foreign power, financial power, whatever, European Union. So that means that basically, of course, you could still argue that there should be more powers for the Parliament in this. But again, you could also argue that that is basically up to the constitutional organs of the country itself. You know, the Rijkswet just says the Prime Minister must agree. I mean, how you regulate how the Prime Minister gives his agreement, you might perfectly regulate that the Prime Minister may not give his agreement without the consent of the majority of the Staten, or something like that. But that's up to St. Martin itself. That does not necessarily have to be in the Kingdom Act. So this, and like I said, in my opinion, this was simply a clear violation of the Charter. I mean, you can't get around it. Even if you take the rather limited approach that the Council of State has always taken to the question, when is a treaty not in accordance with the Constitution? They've always said, well, when it's not in accordance with the text of a provision in the Constitution. If you take that very limited approach, even then, I would argue that this provision in the Rijkswet Coho was a violation of the Charter because it violates the text of Article 26 of the Charter. But with this amendment, this change that now the Prime Minister must give his consent to Coho before Coho can enter into such an agreement, I would argue that that, well, removes a lot of the problems from this provision, and I would say that this is an adequate solution for this very justified critique. Yes. Yeah. Also, quite an interesting, but also sort of rather problematic provision that was foreseen originally was that the Coho could ask the Council of Ministers of the Kingdom, when Coho deemed a country to be lacking in its enthusiasm to fulfill its obligations, that then the Coho could ask the Kingdom government to enact one of the powers of Article 50 or 51 of the Statute, of the Charter. And this again seems to be something of an oversight by the civil servants writing the draft. At least that's what the Council of State assumes in its advice. The Council of State said it appears that the government simply did not think about what this means for the position of the governor. The governor did not play, there was not a single sentence about the governor in the whole law proposal. But very obviously, the governor, in his capacity as organ of the kingdom, has the power to not ratify a country ordinance. Is that the official English translation of landsverordening? Country ordinance? Yeah. Of not ratify, that's obviously one of the powers that the governor has under the reglement voor de gouverneur. That Kingdom Act. And the Council of State said, now assume that a certain landsverordening, a certain country ordinance, national ordinance, that's right, national ordinance, I now remember, national ordinance, of course, yes. There's a certain national ordinance, yeah, you said that, right? I just didn't hear it correctly. Sorry about that. That a certain national ordinance is in conformity with kingdom law and the Charter. And so the governor decides to ratify that national ordinance. And now Coho comes and says, no, we believe that this national ordinance violates the obligations under the Rijkswet Coho, which of course is one of the higher regulations that the governor should take into account in deciding to ratify or not ratify a national ordinance. Well, the Council of State says, that's an impossible situation. When the governor has decided it's okay, Coho decide it's not okay, that means that the governor, in his capacity as, you know, well, he's not completely inviolable like the king, but still, he's not to be brought into political conflicts. And this whole capacity of this whole power of not ratifying a national ordinance very obviously is not meant as a political power for the governor, but simply as a pretty straightforward power when it's utterly clear that something agreed upon by Parliament violates the Charter, a Kingdom Act, or what have you. Then the governor can do it. I mean, it's very obviously not meant as a political power to say, well, Parliament decided this, but I'm not going to sign it. That's not what's supposed to happen. So now you have the governor deciding this is okay, and then the COHO says, no, it's not okay, and then the kingdom government acting upon it. The Council of State said, this potentially brings the governor into an impossible position because it threatens to involve the governor into political disputes. That is very, very, very unwishful. It appears that this is again something that The Hague simply did not think about. Because the reaction was basically, oh that can happen. Oops. Or something like that. And again, this whole provision has been removed from the Act. Simply taken out. So now this threat to the position of the governor, to politicize the position of the governor, especially as kingdom organ, has happily been removed from the law proposal, which I would say is a very good thing. Sticking point, important sticking point, the board of COHO. It is to contain, it's a 3-person board, right? The president and 2 members. And originally, the law proposal said nothing more that one of the members should have an affiliation with the Caribbean region. Now, what that is was not clear. Who was to decide upon that was not clear. And again, it was very much not the case that the law proposal differentiated. I mean, an affiliation with the Caribbean region, what does that mean? That you went to Miami 3 times in your life or something? I exaggerate now, but it can mean anything, right? And it doesn't differentiate entirely between Aruba, Curacao, St. Martin. So it was very unclear what that meant. Now, a lot of critique came, again, not only from the Council of State, but also from the Councils of Advice. And the law proposal has been quite seriously amended in this point. Because it now says in Article 9, het COHO bestaat uit 3 leden onder wie een voorzitter. That is still the same. Benoeming van de leden vindt plaats op grond van de deskundigheid die nodig is voor de uitoefening van de taken van het COHO en op grond van de maatschappelijke kennis en ervaring. Met dien verstande dat tenminste 2 van de leden onder wie de voorzitter aantoonbare affiniteit hebben met de landen. So they're still appointed not because of their origin in the Caribbean, but according to their capacities and knowledgeability. But 2 of the 3 members, including the president, must have an affinity with the countries. So it was 1, it's now 2, including the president. That also means because decision-making in the board is by majority of vote, and when de stemmen staken, how do you say that in English? When the votes get stuck or something, can you say that? Yeah, well, then the president has a deciding vote. And the president must now be somebody with a Caribbean affinity, an affinity with the countries. They are appointed by royal decree, that's not very surprising, for a period of 3 years and can be reappointed for another period of 3 years. So 6 years is the maximum. That seems to be because the act is meant to last for 6 years and no longer. And we all know, based upon what happened with the CFT, that is then undoubtedly going to be the case. 6 years and no longer, right? I'm a bit cynical now, yeah. But at least the act as it is seen now is meant for a 6-year period, and so the members of the board are to be appointed for no more than 6 years. And this appointment by royal decree can only be brought about after a conclusion of the Council of Ministers of the Kingdom. So there must be a decision, in which the 3 ministers plenipotentiary are taking part. And then, under 4, Article 9 says the procedure die voorafgaat aan de voordracht, so there is a proposal for this appointment, is als volgt. Ten behoeve van de voordracht van 2 leden, onder wie de voorzitter, zendt onze minister een lijst van benoembare kandidaten aan de benoemingsadviescommissie, bedoeld in artikel 10. There is a new benoemingsadviescommissie. I will get into that in a second. Ten behoeve van de voordracht van 1 lid zendt de benoemingsadviescommissie, bedoeld in artikel 10, een lijst van benoembare kandidaten aan onze minister. So this is sort of a ping-pong. 2 members of the COHO are to be appointed on a proposal from the Minister of Kingdom Affairs sent to the benoemingsadviescommissie. And one of the members is to be appointed on the proposal sent by the benoemingsadviescommissie to the minister. There is an open procedure, so it's going to be, an open candidacy. People can actually apply for being nominated, where, well, for 2 of the 3 candidates, it must be the case that they can show that they have a Caribbean affinity. And Article 10 then says that there is, for each appointment in the COHO, a benoemingsadviescommissie. De benoemingsadviescommissie heeft tot taak onze minister te adviseren welke kandidaat wordt voorgedragen voor benoeming. De benoemingsadviescommissie bestaat uit 3 leden. De leden worden als volgt aangewezen. 1 lid in overeenstemming met het gevoelen van de Raad van Ministers van Aruba, door onze minister van Algemene Zaken van dat land. 1 lid in overeenstemming met het gevoelen van de Raad van Ministers van Curaçao, door onze minister van Algemene Zaken van dat land. En 1 lid in overeenstemming met het gevoelen van de Raad van Ministers van Sint Maarten, door onze minister van Algemene Zaken van dat land. So this benoemingsadviescommissie consists of 3 members, 1 appointed by Curaçao, 1 appointed by Aruba, and 1 appointed by Sint Maarten. They have to advise the minister on the appointments of the members. And one of the members is to be appointed not just based on their advice, but one of the members is appointed on their proposal. So that candidate is selected by these 3. The other 2 are candidates selected by the Minister of the Interior, but the benoemingsadviescommissie must give advice on that nomination. And this benoemingsadviescommissie does not contain any Dutch members. It is solely a Caribbean committee. Now, of course, this is not a situation in which Aruba, Curaçao, Sint Maarten nominate the members or something, but it is a lot more than was originally proposed. And I've been told in The Hague that the logical alternative, the 3 members are appointed by the 3 countries, that is a no-go for The Hague. That's not going to happen. This is as far as The Hague is willing to go. But I would argue it's a lot more than was originally intended, and you can certainly say that the combination of the fact that 2 of the 3 members, including the president, which has the decisive vote, have to be Caribbean affiliated, and that this benoemingsadviescommissie has quite a serious and a strong say in the selection and advice on the appointment of the members, leads to the situation when there is at least quite a strong influence of the Caribbean countries on who's going to be on this COHO, on the board of COHO. It's not a direct appointment, that's true, but it goes a long way of at least giving Aruba, Curaçao, and Sint Maarten a very serious material influence on who's going to be appointed in COHO. Especially when you compare it to the original proposal, in which basically the Minister of the Interior decided himself who this was going to be, and he only had to make up for himself that 1 member should have a Caribbean affinity, and he would decide for himself what that actually meant. Spending 3 holidays there or something. Of course, I'm hoping to get nominated. I have a very serious Caribbean affiliation. A rather serious point of critique of the councils, the 3 councils also, was that the relationship between COHO and the parliaments was rather unclear, which is true. And a problem, because the powers that this whole new structure is going to bring no matter what we say about it, is going to interfere with the financial powers of Parliament. Of course it is. The budgetary power is going to be influenced by this. There is no going about this. To address that, the law now says that every 3 months, if a parliament of a Caribbean country so wishes, Coho will come to the Staten and give a presentation on what they're doing. And you can then ask them questions, give critique or whatever. Obviously, I mean, they're not ministers, so they're not accountable to you, but they can inform you about what they're doing, which means that Parliament can get the necessary information to be able to influence those it can influence, namely the ministers. And as we've seen before, especially the Prime Minister, in a lot of cases, is the coordinating figure between Coho and the country, which means that Parliament can, by activating ministerial responsibility, try at least to influence the Prime Minister in what he's actually doing in relationship to Coho. But in order to be able to do that, you need information, and Coho can now, every 3 months, provide that information directly to Parliament. Also, the landspakketten, so the measures agreed upon between the government of the Netherlands and the government of Aruba, Curaçao, St. Martin on the measures to be taken to fulfill the obligations in order to get the necessary money to bring your economies back to life, these landspakketten now have to be presented to the Staten. That wasn't envisioned originally. Originally it was just a government affair. But these landspakketten have to be brought to the Staten in their entirety. Which means that because they have to be presented, and obviously, I mean, you could argue that a decently functioning parliamentary democracy means that a government will obviously bring those landspakketten to the Parliament on its own accord. But to make sure that that happens, the Rijkswet now says so. It must be done. So that enables Parliament to review in their entirety these landspakketten and to propose proposals for a betterment or amendments or what have you, and to bring those that critique to the government, again activating ministerial responsibility, makes sense in this case, so that the country government, in its negotiations with the Netherlands, can take that information and those wishes of Parliament into account. Is this ideal? No, it's not, but it most certainly is a strengthening of the roles of the parliaments in relationship to the original proposal. Except for the powers that I mentioned under Article 22, so the power of the Minister of BZK not to grant money, all other decisions of either the Minister of BZK or the Coho itself are now appealable through a procedure laid down in the Act itself in a reference to the Rijkswet CFT. So the procedure is basically the same as the one that we are familiar with since 2010, the so-called kroonberoep of, what is it, Article 36 or so of the Rijkswet Coho. The Prime Minister of a country can bring a case before the Council of State if he rejects a decision, in this case of Coho. The Council of State gives an advice. In as far as that advice is legal in nature, it is binding upon the Kingdom Government. In as far as it is political in nature, the Kingdom Government can deviate it from it, but only because of very serious reasons, and those have to be motivated and published in the Staatscourant. Now, you have some familiarity with this procedure. There are certain occasions where the Kingdom Government had taken decisions under the Rijkswet CFT in which the Council of State has says, no, the country is right. Curaçao has 1-2 cases. So this is a procedure that at least has shown that it has a certain merit. It's not completely symbolic. And I would expect that the same would be the case under the Rijkswet Coho. So the appealability of the decisions has been seriously strengthened, It's not an appeal on a judge, but yesterday we discussed this, of course, the pros and cons of this. It is kroonberoep, but it is quite a serious form of kroonberoep where the powers of the kingdom government to deviate from the advice of the Council of State of the kingdom are severely curtailed. And like I said, in as far as the advice of the Council of State is legal in nature, it is binding for the kingdom government, and then they cannot deviate from it. And the same then would be the case under this act. Which brings me, I think, to my last and final point, namely the character of COHO as a Dutch organ and the applicability of the Kaderwet Zelfstandige Bestuursorganen. That's a Dutch act that was enacted, I think, in 2010 or so, and it's the last remnant of a very ambitious attempt to regulate the entirety of the zelfstandige bestuursorganen in the Netherlands. That has backfired. The Kaderwet that came out is far more limited in nature, but it contains 30 or 40 provisions that are essentially applicable to all zelfstandige bestuursorganen in the Netherlands. Certain of these provisions are now also applicable on the COHO. What are these? Well, and this is worth looking into, because these provide the Minister of the Interior with certain powers vis-à-vis COHO that are not clear from the Rijkswet itself, but are only clear if you look into this Kaderwet Zelfstandige Bestuursorganen. On the other hand, it also contains certain obligations for COHO, which are also to do certain things in a certain manner that would also not exist if the Kaderwet Zelfstandige Bestuursorganen would not have been made applicable. When it comes to the powers of the minister, these are mostly the following. COHO cannot give any power of remit without the Minister of the Interior giving his consent. Mandaat, it's not possible. Its bestuursreglement, so its internal policy rules, must be approved by the Minister of the Interior. COHO must provide the Minister of the Interior with all the information the Minister deems necessary. That's Article 20. The Minister of the Interior can make beleidsregels, so rules of procedure, for COHO. That's in Article 21 of the Kaderwet Zelfstandige Bestuursorganen. Any decision made by COHO can be annulled by the Minister. Article 22 of the Kaderwet Zelfstandige Bestuursorganen. That's an interesting one. I have not found any clear indication about the relationship between the applicability of this provision in the Kaderwet Zelfstandige Bestuursorganen and the relationship that the Rijkswet COHO itself provides for the between the minister and the COHO. It seems, apparently, that all decisions, so, without this whole, separate from this whole procedure of applicability or appealability for the countries, it seems that the Minister of the Interior has the power to annul any decision COHO makes based upon the Kaderwet Zelfstandige Bestuursorganen. And then COHO can go to the afdeling bestuursrechtspraak to fight that, because that's what Zelfstandige Bestuursorganen can do if their decisions are annulled by the minister. But that's something that is completely outside of the scope of St. Martin, Aruba, and Curaçao. And I have not found anything in the law proposal or the Motie van Toelichting explaining how we should look at this. Of course, in reality, it's very, very seldom the case that a Dutch minister annuls a decision by a zelfstandig bestuursorgaan. That almost never happens. But the power is there. So again, this is something I'm not entirely sure whether this is well thought through, or it's also simply something that has been, overlooked. Because what exactly happens if the afdeling bestuursrechtspraak decides that COHO is right, and annuls a decision by the Minister of the Interior to annul a decision by Coho, what happens then in relationship to Sint Maarten? I don't know. Like I said, it seems that this also is not something that is... There is a lot in this still. You can still see that this is a law proposal that was written, as we say in Dutch, by stoom en kokend water. Very quickly. You know, it all happened. The crisis was there in 2020. The Caribbean economies collapsed. Had to do something. A law proposal was written very, very hastily. And I think you can still see some of that has not completely been thought through very well. This also seems one of those... If I were you, I would ask questions about this. How should we see Article 22 of the Kaderwet Zelfstandige Bestuursorganen in relationship to the Rijkswet Coho itself? Or, also possible, is the Rijkswet to function as the lex specialis? So does this mean that when the Rijkswet regulates something else, then the general provision of Article 22 is not applicable? I just don't know. I mean, it would make sense if that's the case. It would seem logical to me as a lawyer, but it's not explicitly there, neither in the Act nor in the Memorial van Toelichting. So, well, I would suggest that you ask questions about this to the government. How are we to see the position of Article 22 of the Kaderwet Zelfstandige Bestuursorganen? Does this really mean that the Minister of the Interior can annul any decision Coho takes? And what does that mean for us if that happens? Because under existing Dutch law, that only means that the Coho can appeal that, because it is directly involved. But it will probably concern matters relevant to Sint Maarten, Aruba, and Curacao. So how are we to look at this? And like I said, I just don't know. So I'm interested myself in what they would come up with. And I wouldn't be surprised, like I said, if they simply did not think about this yet. That this was simply overlooked again. Also important, but potentially beneficial to Sint Maarten, Article 23, the Minister of the Interior can make provisions when Coho seriously neglects his legal duties. So if that, in the opinion of Sint Maarten, Curaçao, Aruba, that would happen, you can go directly to the Minister of the Interior and say, look, we believe that they're not doing what they're supposed to do. I could think of stronger terms, but I won't use them because we're in Parliament. But you can go directly to the Ministry of the Interior and say, act upon this. He has this power under Article 23 of the Kaderwet Zelfstandige Bestuursorganen. This is also a power that is in the Netherlands almost never used, but it's there. So, and finally, Coho's budget needs the approval of the Minister of the Interior, which is, you know, the same for all, basically all zelfstandige bestuursorganen. They have a budget that needs approval, otherwise Parliament would not have any grip upon the budget, which is sometimes very large, of zelfstandige bestuursorganen. And since Coho is mostly provided by Dutch money, it sort of makes sense that the minister should have the power. I mean, this is one of the articles which I can understand that you would apply to Coho, that the minister would, because otherwise there would be no democratic control on the budget of Coho, because it is an entity with a separate budget from the state itself. Which brings me basically to the end of what I had prepared for you as a short analysis of what the law now looks like. Well, and I'm wondering if, and I can imagine that some of you might have questions or follow-up remarks or whatever. So, Madam Chair, I thank you.
Thank you so much, Professor Hoogers, for that presentation, for that extensive presentation. Before I turn over the floor over to the members of Parliament for questions or statements they may have, I'd like to just take a 5-minute adjournment, and then we go over to the questions. Meeting adjourned for 5 minutes. Welcome back, members of parliament. We have just taken a brief adjournment, and we just had a presentation by Professor Hochers, and now I'd like to turn the floor over to the members of parliament for any questions they may have. And I see the first member of parliament is MP Sarah Westcott-Williams. You have the floor.
Thank you, Madam Chair, Lady, and a very good morning to you. Good morning to our Secretary General, my colleagues here in Parliament. Good morning to all tuned in to this meeting. Good morning to Professor Hochers. Welcome back after yesterday on a different topic, still, in my opinion, sort of related, but thanks again. And thanks for your paper and your elucidation here during the meeting this morning. You know, Professor Hochers, the matter of the coho, I think for us to understand and pursue whatever direction we want to pursue with the coho, we need to understand the premise on the basis of which it came into being. And yes, based on Council of State, councils of advice, some changes have been made. But as long as we don't address the premise on which it came into being, we will be trying to fix something that has more underlying motives. What do I mean with that intro? The fact that the Landspakketten actually came about in what I consider a moment, or maybe a long time, of impatience by the Dutch government with the countries. And so, following the onslaught of the COVID pandemic, and of course now the countries, including St. Martin, were like, what do we do now? You know, this has hit us, it hit us hard. And the Dutch government was exactly at that time asking the countries, come up with a reform package. Come up with a reform package. You need to do your work, kind of. The three countries, albeit at 5 minutes to 12, prepared their own reform package. That's a fact. However, these came together when the government / the Dutch ministry had already decided, now we're going to have to take this thing into our own hands. So, firstly, a sort of a blanket country package was developed primarily by the Dutch ministry, with in the back of their minds these reforms that they had gotten from the countries. And then the question would be, how can we ensure that for once and for all, the countries stick to an agreement? And the bright ones at the Ministry of Interior Affairs and Kingdom Relations came up with the coho construct. So we need to deal with that premise, that environment, that contentious or contention that was there very, very strongly. Do not be fooled by the fact that because of the pandemic, we receive immediate help in terms of our public health situation, etc., etc. That was good, it is fine, and we got it. But that premise of impatience with the countries and what they're doing led to what we have in front of us now. And yes, attempts have been made and it has been softened. But if we don't deal with that premise, even where you have the many unclear situations that you mentioned, in working those out, we're going to have more contention. So where the law kind of nicely says, well, the Prime Minister and the Minister of Interior Affairs can talk about this, can agree, can consult. All of those things are only going to make this matter contentious. Do you understand what I'm saying, Professor Hochers? So we need to go back to that basis there and see what kind of amends can be made. That's one. The matter of to come up with such a far-reaching body for actually, there is no, we read what the Minister of Interior Affairs can do and can assist with. But to me, that's the carrot and stick type of, you can get this. So while the countries are committing themselves to all of what we are committing ourselves to, how it's going to be financed is left up to see when we get there, sort of. In addition to that, the matter of liquidity assistance, which is an important part in terms of complying with the Landspakketten, etc., is only going to make an already bad debt situation of the countries worse. So we right now and St. Martin are between a rock and a hard place. Because on one hand, you have that happening, but on the other hand, CFT right now, is clamoring for improvement of our debt situation. CFT is talking about a balanced budget in 2023, mind you. And so if the CFT now, with that brill up, is going to have to work along with the cohort, I foresee, unless we address it in the Kim, I foresee this whole cohort thing becoming even a bigger part of frustration in the relationship between St. Martin and the Netherlands. And when I look, for example, so what do you do if decisions are taken? In the case of the cohort for the countries, of course, we have the article that regulates it's kroonberoep and similar to what is there for the CFT. Again, unless there's a different type of approach from both sides of the ocean to this matter, we have seen how the kroonberoep can go. And, when is it a legal point vis-a-vis a political one? Even over that, you can have all kind of discussions. So the matter of you can appeal it. 1, 2, parliamentary control. We have been told here in Parliament by our government that has agreed to the latest draft that this has been improved. And I'm like, one of the most important rights of Parliament, the budget right of Parliament, is undermined. And Professor Hochers, you said it yourself, so it's not a question to you because you were very clear, the ones we are to hold politically responsible are the ministers. But given what we have today, and again, I want to go back to the issue of the capacity to up to trekken with the cohort persons rather. It's not there. It's not there. Already it is evident that you have a reporting. If the premise for the cohort was really, now countries, we're going to help you. Okay, you have your issues. We're going to help you with the reform based on your local situation. Then you wouldn't have a double reporting. But right now, even with the TWO, the voorloper of the cohort, you have a double reporting. They reporting, and then the government, the two that should be working hand in hand to get this process online and going. And then the government has to say, well, okay, this is my view on what the cohort reported. That alone takes away from the samen optrekken that this whole system was supposed to be. So again, unless we address it from the premise where it all started, and the last time we asked the Prime Minister sitting, I believe, in the very chair that you're sitting, so Prime Minister, what you plan to do? And the Prime Minister said, mend the relationship. But if we're going to say that, we need to be serious and understand what steps we as St. Martin wish to take. Because otherwise, I fear that, we are going to be going over the same thing again. The World Bank, for example, and this construction that the Netherlands agreed to with the World Bank to manage the trust fund was because, they are accusing us, that was the Dutch government's stelling at the time. They're accusing us of political interference. So we're going to get a neutral body and put it there. Okay. And look how that has worked for St. Martin. The only lichtpuntje I see in that is that we created a local bureau, because I believe just like that, just like we took the integrity chamber and against all odds made it via a local national ordinance, there must be something more local and structural to this cohort construction. And that's what we need to think of. How do we do it? I understand the Dutch government. You want to secure the fact that you're going to pay back or get your loans pay back, then limit your influence to making that possible. But the cohort is really, really overreaching and overstretching in order to do that. And the kind of coming together for those structural reforms, sustainable reforms, I don't see it working like that. So in that context, I look at the issue of once we tie ourselves into the cohort, there's no way gaandeweg to say, okay, St. Martin, from St. Martin's side, we have seen it, and we want to get out of this construct. No, we have to go along for the 6 years. So again, as you said, Article 4, Sub 2 is, in my opinion, an empty box. We tend to mention it all the time. Yeah, you can do that unless once it is not in, contravention of et cetera, which is, as I said, which is an empty box. I have a concern with respect to the parliamentary control and the budget right of Parliament. And as I mentioned to my colleague earlier, the country packages, they are established. And now we have the process going on for the implementation agenda. So by the time we get it as Parliament, we could stand here and make a big issue depending on what side of the fence you're on, politically speaking, with the government. But is that really going to give us, any possibility to turn things in a direction that we as Parliament might think? I doubt that very much, given the steps that are taken before it gets here and by whom those steps are taken and by whom the work is done. So, I'm sure for the chair lady of this committee and my colleagues, what I stated is nothing new to them. I continue to state it from the beginning of the cohort. And I think it will behoove us to, with your information, your suggestions, clear suggestions, as a Parliament, to decide how we want to approach this matter as of the cohort. Already, if we look at some of the discussions taking place in the Netherlands, I think we have our work cut out for us. So, Madam Chair Lady, I just want to thank Professor Hoogers for his input. Again, no specific questions. The professor was quite clear in the issues that he has identified for us to look into, and I remain concerned that if we don't together caucus and decide what do we really want to do with and about this cohort construct, as I like to call it. Thank you, Madam Chair Lady.
Thank you, MP Westcott Williams. I'd like to turn the floor over to Professor Hoogers. Maybe you'll have a comment based on what was said, and then the next MP is MP Duncan. So, Professor Hoogers.
Thank you, Madam Chair, and thank you, Member Westcott Williams, for your candid remarks. Allow me, Madam Chair, to make a personal remark that is not related to my specific scientific knowledge or anything, but one of the things that has struck me from the beginning in this is that there is something to the Dutch approach of the doctor who, concluding that a patient he treats is ill, has prescribed antibiotics, and then notices that the antibiotics did not work, decides that the best way to proceed is to give more of the same antibiotics. There is something to that approach in my humble opinion, you can't possibly argue that the CFT has been a resounding success since 2010. And yet, the way that the Netherlands seems to want to deal with that is to invent something even bigger. named Coho to address basically the same issues, where you might argue that, if this kind of approach seems to be not very successful, well then maybe, but that's just, like I said, just a personal remark as a concerned Dutch citizen, if you will, that I make, that of course doesn't have that, as a lawyer, as a legal scholar, I have to deal with what's in front of me and try to analyze that to the best of my knowledge. And this is basically a political remark that I make, but I wanted to make it anyhow. Anyway, one of the things I would like, because that is something that is legally relevant, you said you can even contest when you're dealing with a political or a legal opinion from the Council of State, which is true, of course. Theoretically speaking, that's possible. There is, however, and that has been said during the approval procedure that failed, but still of the Rijkswet Koninkrijksgeschillen, the same issue was brought up by certain members of the First Chamber who said, look, okay, so now the government is if it is a legal contention, then it's binding. But how do we know what a legal contention is? And then State Secretary Raymond Knop says, no, whenever the Council of State says this is a legal objection, that's binding for us. So okay, there is that. I mean, if the Council of State itself says this is a legal opinion of ours, not a beleidsopvatting, but rechtsopvatting, then that is binding for the government, not just that opinion itself, but also the contents of that opinion. So that sort of shows that at least the government claims that it shall never dispute the opinion of the Council of State on when it's giving legal and when it's giving political objections to a decision earlier taken by the Kingdom government. On the issue of appeal, and that's something that I forgot to mention earlier in my presentation, but it's interesting nonetheless. There is a certain, and again, I think this is something that has been seriously overlooked in The Hague, because it might work out surprisingly. I have asked this question to Jan van Rossum, who probably will give the technical briefing to you as well during IPCO, because it's his dossier of the Ministry of the Interior. We have been discussing this, and it's not entirely clear whether he was also thinking that it might be interesting to ask that question if and when he comes here, and then, of course, don't mention that I said this. But it might be interesting to bring it up, because it is a serious question with which I wrestle myself. Apparently, COHO is going to be a Dutch organ, functioning under Dutch law. If that is the case, it seems to me that the Algemene Wet Bestuursrecht is applicable. Because, well, the Algemene Wet Bestuursrecht is applicable to Dutch organs, zelfstandige bestuursorganen, but also organs of the state itself. If that's the case, then one could argue that the usual provisions in the Algemene Bestuursrecht to give, appealability to decisions of bestuursorganen apply as well. You might argue, because the Rijkswet COHO does it, and the Rijkswet CFT does it as well, certain provisions of Chapter 8 of the Algemene Bestuursrecht are declared applicable. You might argue that from that it follows that the other provisions of the Algemene Bestuursrecht are not applicable. But it's not stated very clearly. And for the CFT, it makes sense, because the CFT is not a Dutch organ. But the COHO is. And if the Algemene Bestuursrecht is not specifically ruled out, then I would argue that you could very well make the case that the Algemene Wet Bestuursrecht is applicable. And if that's the case, well then, you can appeal decisions of COHO Bij de bestuursrechter.
Ja?
Yeah. I'm quite sure that that is not intended. But I wouldn't know for sure that is not the case. As long as the act is as it is. So, well, you could decide for yourself whether you want to remain silent on this subject. And if and when this act comes into force, just try it out. And see what happens if you go to the bestuursrechter in The Hague. And I'm not sure that then the bestuursrechter will not say, well, yeah, this seems to be a very ordinary Dutch organ, so it seems to me that AWB is applicable, and it seems to me that I can hear this case. I'm not sure that won't happen if you just try it. I'm not sure that it will happen. I mean, it's also perfectly possible that the rechtbank Den Haag will say, no, that's clearly not meant to be the case. But like I said, I'm not sure that at least this is rather vague. And it seems to me that this has not been well thought through at the ministry again. It's probably not the intention, but, well, so I'll bring it to your attention. This might be an interesting road to pursue, and just to see what happens if you try it. So there is that. Thank you.
Thank you, Professor. I'll turn the floor now over to MP Solange Duncan. You have the floor.
Thank you, Madam Chair Lady. Good afternoon to you. Good afternoon to my colleagues here. Good afternoon to Professor Hochers. Welcome back. Thank you so much for your presentation. On the same sort of thinking, there appears to be a sort of history, or even a, what do I call it? Every time there is a crisis or anything, higher supervision appears, or even a new construct of an institution. And so if we are going to continue to be extremely vulnerable, at least before the pandemic, there were hurricanes, right? And with every major hurricane, there would be some sort of, some form of higher supervision placed on us, I would say. If we're going to continue to be vulnerable, now with pandemics, with a war, with even more and stronger hurricanes, wouldn't there be a permanent solution to this issue when it concerns the fact that there will always, at least for now, be a need for reforms, and there will, I don't want to say always, but there will be a need for financial support and assistance. We've been looking at the way in which the UN, through the UNDP and the World Bank, has sort of come into the Caribbean permanently, have set up offices. There is the Sustainable Development Goals and so forth, which to me is the answer to development needs and reforms, and then the World Bank being that organ to financially support projects and supposedly create or strengthen the financial resilience of countries. So with these two organizations that do find themselves on St. Martin, and not only on St. Martin now, but have really have existed in the Caribbean as a whole for quite some time, wouldn't they be alternatives to the coho, in your opinion, or what could the relationship between these organizations and the Dutch government or the Kingdom government be, in your opinion, moving forward? Because we're going to continue to be vulnerable. We're going to continue to, face crises and storms and pandemics. And I just see us kind of continuing in this loop. And so I'm asking, what would your opinion be, Professor, on these organizations and alternatives to coho or maybe support? Yeah, thank you, Madam Chair.
Thank you, MP Duncan. Professor Hochers?
It's a very good question. I don't know this, so I'm speculating. But I can imagine that after noticing that, working with the World Bank wasn't such a spectacular success, The Hague thought, well, let's try something else again, and came up with Coho. I'm sure that working with the World Bank could be an alternative, and it would even be possible for St. Maarten to do that basically itself, because obviously St. Maarten has under the Charter the power to, enter into relationships with international organizations that allow non-state actors to interact with them. And the World Bank statute allows for non-state actors to work with them. Well, that happens right now, in fact. So the World Bank works with the St. Maarten government. If that, however, would lead to a situation where St. Maarten would be more master of its own fate than in a proposed Coho, I'm not sure. I mean, and I don't mean this cynically when I say I'm not sure, although you know me by now well enough since yesterday that sometimes I can be a bit ironic and a bit cynical, but this I simply mean I don't know enough of how the World Bank works. I'm not an expert on international finance and on the functioning of these kind of institutions. What I do know of them is that they quite often seem to be quite bureaucratic, heavy-handed in their approach, not only with you, but also with, for instance, African countries with which they have worked. So I don't think that I would be too enthusiastic of the idea that the World Bank would be a decent, replacement for dealing with the Dutch government. However, I would fully agree with you that there is need for Coho. It still shows that this is a crisis organization. The whole act, I said that earlier, but still bears some resemblance to the crisis situation of the summer of 2020, when your economy and the other Caribbean economies basically, collapsed, and something had to be done, and money had to be found, and all on top of Irma, and the next Irma, we all know that is on the horizon somewhere in the next 10 years, something like that is going to happen again, probably, God forbid, but you don't have to be a sightseer or farseer to know that it probably is going to happen. And like you said, storms are going to be stronger, apparently because of climate change. So there is a, you see, sometimes I feel that Dutch politicians and also Dutch civil servants don't really grasp the vulnerability of the scale of your societies. Sometimes it seems that all four of us are basically caught up in this language game while we're four countries. Sometimes it seems to me that Dutch politicians and Dutch civil servants and other, simply Dutchmen, if they know anything, most Dutchmen don't know jack shit about, he says it again, I'm so sorry, but sometimes, this is my frustration also coming out. So many of my countrymen don't know anything about this part of the kingdom, although sometimes they assume that they know something of it, and that turns out not to be the case. But even if they do, it quite often, sorry, Madam Chair, like I said, this frustration coming through for a second, of years and years of having to deal with this, anyway, the situation where sometimes even people who do know more of it, that this the big suit that I was talking about yesterday fools my fellow countrymen as well, but they're a country, right? They have a government, they have laws, they have, all true, yeah, they have a country, they have a government, they have a parliament, they have laws. but it is a society of 100,000 people or 60,000 people, of 150,000 people. These are small societies having to deal with, for instance, I mean, why don't they diversify their economy? Sure, let's start agriculture, why not? Where? Or as former Prime Minister William Marlin, Marlin told me a couple of years ago during a lunch we had, sometimes the Dutch tell me, you should build more roads, to stop congestion. And then I tell them, where exactly? I really to laugh about it because, yeah, where here on the island? You want me to build those roads, right? It's well, in short, yes, I do believe that there is need for a more structural solution to the vulnerability, and of course the vulnerability of the Windward Islands is even because of hurricanes is even greater than that of the Leeward Islands. Yes, generally speaking, I mean they might occur there as well, but they will probably occur more here. So, and I'm not sure that the present Dutch government and the former Dutch government, the Dutch political culture has grasped that already. Sometimes it seems that there is in The Hague a sort of point on the horizon that we're aiming to reach, and that point of the horizon is one day Aruba, Curacao, St. Martin will be resilient. One day they will be financially independent. One day they only have to work towards it with our aid, of course. And the idea that some of this is never going to be reached simply because these societies are too small, too vulnerable to be able to do that all on their own. I sometimes feel that realization is simply not there. And so you keep walking from incident to incident, and it's always treated as an incident instead of an aspect of a structural and basically insoluble problem. Well.
Thank you, Professor. I will have the next on the speakers list. We have MP George Pantaflet. You have the floor.
Thank you, Madam Chair. Good afternoon to the Chair, my colleagues, Parliament, Honorable Guest Professor Hochers. Madam Chair, let me say this through you to the Professor. You have not disappointed me at all. Definitely the information that has been brought forward, indeed, very direct, very candid, and the explanation as to the understanding of I use the term European Dutch with regards to our realities, definitely very far from each other. I like the example you used with the issue of the medication, where we are being given the same medication and so on, and still can't find a cure because, as I always tell my doctor, I said, Doc, you are the one who has studied the body parts and everything. You know certain medication, but I know where the pain is and where it hurts me. So basically, I should tell you exactly where it's hurting me, and then based on that, you get a medication, not the other way around, which happens unfortunately. The issue of the pandemic, Madam Chair, through to Professor Hochers, definitely we know for a fact that, and my colleague that just left mentioned it, this was an opportunity for the Dutch government to use whatever plans they had for these islands in order to cover these conditions. Yes, the reality is that there are certain reforms that should have taken place. I would not stray away from the responsibility of ourselves as government, parliament, politicians, where for the last 10 years there has not been any stability in government. And that has contributed also a lot to what is taking place today, because if there's no stability, then whatever plans you put in place, unless the incoming government decides to go with it, then of course it's put aside, and then you come with new plans again, and you never get things done. And who suffers again is the population. So I believe that the Dutch government used that opportunity in order to come with the conditions that they came with. And the conditions, and I'm happy to see where the new state secretary, and as I said to some of my colleagues and some friends, I believe that she's making a serious attempt in order to not only address, but to also address is the right word, yes, also, but also bring us back to the point where there is mutual respect and understanding for us, regardless of the size of the countries, but to understand that we have our own cultural differences and so on, experiences, and therefore, you quite excellently detailed it as to the aspect of how they look at us down here and how we actually are as to our experiences on the island down in the Caribbean region. But again, I definitely thank you for the explanation, and also the issue of the coho. I do have some proposals myself, which I'll keep to myself right now. They'll only come out later once we discuss the coho further, because honestly, right now, as I'm saying, for me, coho is no go. My statement is basically that if I have to discuss a law proposed by you, then of course you will make sure you put within that law itself certain articles and certain phrases that will give you the control over whatever decision is taken. And if I have to go and debate you on your law, definitely the procedures themselves has to follow a particular structure. And therefore, I'm asking myself, is it a structure that I can include third parties? Is it a structure prescribed by you? When I say you, I'm talking about the proposals of the coho law, that in the final analysis will end up being what it is you want it to be, not what we want it to be. So I'm very skeptical about those issues of yes, you can appeal and so on to the higher courts or whatever, because again, yeah, looking at the dispute regulation where I believe a judge ruled about the decision being binding, and then the government said, no, it can't be binding on us, so put it aside now, and you, the islands, come with your own proposals, knowing very well that the capacity to do so at this time, financial-wise and also experience-wise, is very limited. Something that I've been championing all the time, and unfortunately, I was reading a report that came out due to the visit of the State Secretary on St. Martin, and I believe also the First Chamber. And I was a bit disappointed because they mentioned different aspects and so on, but nothing was mentioned about the request that I made as to the issue of debt cancellation. And that was not mentioned because, as I was told to my face by the State Secretary, that it's a hard sell. I was also told by one of the members of the First Chamber that it's a Dutch taxpayers' money. And I was told by the CFT that it's a political issue. That, in my opinion, I believe that that's one of the roots. If you want to talk about St. Martin having what you call financial independence, then I believe that's the route to go. But that's only my opinion based on research that I've done, where at present the debt that we owe to the Dutch government runs in the tune of 1.4 billion guilders, and at a rate of 12.7 million that we're paying on an annual basis, it will take us some 100 years to repay that debt. And right now we are getting loans and loans. So if you really want us, when I say you, I'm talking about the Dutch government to really be financially independent, then you should start there, because we will never be so if we are still given loans, and then now we are faced with a coho which wants reforms to be done based on our own financial capacity. The issue of the TWO, that for me, Madam Chair, through to Professor Hochers, is not clear. For me, the TWO is the coho, and they're looking to give it a legal basis. That's how I see it. I could be wrong, but I don't see a difference between the coho and the TWO. That's my opinion. Also, Madam Chair, the issue of the process as to the time we have been given by the Dutch government to deal with the coho. I believe they had 20 months or whatever, and now we are given by May the 15th or something that they want, May the 20th they want to get a response. Well, they can stipulate whatever they want. I believe it's up to the three countries to decide exactly how much time we need when it comes to that matter. Another point, Madam Chair, is the issue of the Article 26, I believe, of the Charter. And I'm glad Professor Hochers is here, because he's a lawyer too, so he can really give us a good explanation. And because sometimes you see articles and then they have explanatory notes, and other times they have none. Like the one, I think, Article 36 concerning Aruba, Curacao, and Martin should help each other in times of distress, but there's no explanatory notes as to how that should be done. And I find that was very, very interesting. But Madam Chair, Article 26, just one explanation on that article. And I agree wholeheartedly, Madam Chair, with Professor Hochers, a little bit not with my colleague, and we don't go on the World Bank, because I've always said World Bank, IMF, those institutions, they give you the same medication that doesn't work at all, and they don't look at your size, but they look at their procedures and their guidelines. And for me, it is a recipe, a format for them to keep us dependent and so on, and to take care of those who I consider the elites. In closing, Madam Chair, the United Nations Charter, and I was trying to find it, but unfortunately I can't. I think somewhere it is mentioned that, especially in our case, who were, let's say, quote unquote, former colonies, that the colonizer has an obligation to ensure that before we are able to stand on our own 2 feet, let me use it that way, that they assist us in the whatever administrative, financial capacity in order to ensure that when we become independent, that we are able to handle our own matters. Having said that, Madam Chair, I want to thank Professor again tremendously. Thank you very much for your candidness and so on, and explanation on the different matters. Thank you very much, Madam Chair. Thank you.
Thank you, MP Ponderflat. I don't think MP Ponderflat had any questions, but I don't know if you have any. No? Article 2. Okay, yes? Okay, Professor Hokers, you have the floor.
I think, Mr. Ponderflat, you actually have 2 questions, one on Article 26 and one on the difference between de tijdelijke uitvoeringsorganisatie en, yes. I was correct. I did pick that up. Thank you. First on Article 26. Yes, as I said before, I truly believe that what was originally envisioned would have violated the Charter, and would therefore, and I also wrote that down in an article that I wrote last year, that should lead to a situation where that law cannot pass Parliament, because obviously the Kingdom legislator cannot pass legislation that contravenes the Charter. So the law as it stood would, in my opinion, clearly have violated Article 26 of the Charter and would have therefore been unconstitutional. But the Council of State has pointed that out quite clearly, and Article 20, or the Rijkswet Coho, has now been amended so that Coho cannot enter into any financial agreement without the consent of the Prime Minister of St. Martin. And I would argue that that takes away that inconstitutionality, because now without the consent of and of course you could put up a whole discussion, it's a Prime Minister, shouldn't that be the government, or shouldn't that be the government and Parliament together? Yes, perhaps, but I would argue, as I said before, that is something that perhaps should not be in the Act, but that is something for the St. Martin constitutional organs to work out together. I would argue that it would be very unwise and perhaps even inconstitutional under the staatsregeling for the Prime Minister to do this completely on his own, on her own in the present case. But given the position under the staatsregeling of the Prime Minister in relation to other ministers, that would, in my opinion, be unconstitutional. This should be a decision of the government. And given ministerial responsibility, perhaps even the consent of Parliament should be taken into account, because a financial agreement would interfere, again, potentially, with the budgetary rights of the Staten. So, but that is something, like I said, for the St. Martin constitutional organs to regulate amongst themselves. For government to come up with how the Prime Minister is enabled to do that, and for the Staten how to do that in relationship to the government. That's not something, I would argue, that should be in the Rijkswet Coho, because in the long run, it's not up to the Kingdom legislator how the St. Martin constitutional organs interact with each other. That is a basic point, I would say, of St. Martin constitutional autonomy, how that takes place. The relationship between the tijdelijke uitvoeringsorganisatie and the proposed Coho, well, there are, practically speaking, they're doing the same things, of course. In that sense, I would argue that you're completely right. But the tijdelijke uitvoeringsorganisatie is just basically a bunch of Dutch civil servants doing what Coho is supposed to do, because Coho doesn't exist yet. So there is not really a legal basis for all of this. And from the point of view of the legality principle, that is, of course, problematic. So the difference is going to be that when Coho exists, there is going to be a formal act regulating it, regulating its powers, and there are not going to be just a bunch of civil servants from the Ministry of the Interior, but there is going to be a board. We discussed how that's going to be nominated and appointed, and civil servants working for that board instead of working for the Dutch Minister of the Interior. So I would argue that at least from a legal point of view, that does make a difference. Thank you.
Thank you, Professor. I would like to go to the next Member of Parliament, MP Christophe Emanuel. You have the floor.
Thank you very much, Madam Chair. Good morning, good afternoon to you, my honorable colleagues, and again, good afternoon to the esteemed professor who is here with us today and the lovely people of St. Martin. Madam Chair, through you, I have no intentions to be nice with my deliberation here today, and it is not to the outcome of the good professor. It's just, as we say here in St. Martin, it's what it is. But I must thank the professor for his choice of words and his deliberation concerning the Coho, knowing that it's an invitation from Parliament that he is here today. So I am sort of pleased with many of the things that you had to say, because I have been resounding those same things for quite some time. I have been one who have said that I'm not even going to entertain a discussion with or about the Coho. And deep rooted inside of me, there are many things and reasons why. I want to ask through you, Madam Chair, to the Honorable Professor, if he's familiar with the laws or the phrase or the entities in the Deep South in the United States called Jim Crow, if you're familiar with it. And with that being said, my first question to the Honorable Professor, if you're also familiar, or can you give the existence of the word, where did it come from, rooted the word apartheid? Where did that word come from? What's the origin of that word? And it's a reason why I'm asking those questions, because I am spiritedly disappointed with the Dutch government for assuming, and even much more disappointed with my government for consenting. The Dutch government assuming that they can stay from where they are and look at us, like you made mention, and decide that reforms are needed. And for the government of St. Martin to consent and say, yes, there are many things that we should have done a long time, so yes, we can see that. No, absolutely not. And here's the reason why. Madam Chair Lady, the Dutch entity called the Netherlands as a country gained their independence in what year? 1648, I would want to believe, or I stand to be corrected, from Spain. And Spain recognized them because of a growing conflict with France. Spain had to sort of released because they couldn't maintain. And in 1648, they recognized the independence of the Netherlands, recognized it. So here we have the Netherlands making their reform and building their country for 374 years. But in 12 years, St. Martin must make those same reforms. And in 12 years. And what made me even open my eyes even more, listening to what you're saying, is the dichotomy, the difference between them and us. When I listen to most of what you're saying and most of everything coming from the Netherlands, I keep hearing they and us, we and them. And I'm not hearing Dutch citizens together. I'm not hearing those words. I am hearing you are there and you should do those sort of things down there and we are up here. We keep hearing this separation. A separation is what we keep hearing. And you made it clear that some of your colleagues and the explicit words that you use, I just love it because it came from your heart. But many of your colleagues have no clue whatsoever happens to us here in this region. But specifically to St. Martin in this region within the kingdom. St. Martin is different and much more unique than any other territory within the kingdom. Because, yes, our economy did not collapse because of a pandemic. Our economy was halted from way before the pandemic. Not Aruba and Curacao. They don't experience hurricanes. We do. So we was hit twice. And that's the difference. So it can't simply be you bottle them all up together and put that law and it works for them. It cannot work. We are different. That jacket will not fit, will never fit. And the major problem that I have, why I said I'm so disappointed, is when it is ever the Netherlands is finally going to say, St. Martin, let me hold your hand and show you and help you how to be much better and not demanding and conditioning what you should do. That's what I get in terms of the difference. And they use the opportunities over and over and use their liquidity as a tool to bind us for what they think is best for us. It's a problem, Professor. And as long as we, hear the term that I'm using, we, in terms of being citizens within this kingdom together, if we don't come together and map out what best suits us with your assistance, it's never, ever going to work. We are always going to have that difference where you're the colonialist, you did what you're doing to me and my ancestors that have you in a privileged position today. It's always going to be that way. And here comes the coho. Because for whatever reason, the Dutch government feel that we can just simply spring the coho on us because they can. And that's what it is. Simply because they can. My colleague made mention of it, and I have been saying this from day one. We came out of the Netherlands Antilles. We came out of 10-10-10 with $600,000 in debt. And I'm talking about the entity island of St. Martin, not Curacao and Aruba, St. Martin. That's the debt we carried with us. What does the Dutch government do and say? You need budgetary oversight. So we are going to put another entity called the CFT. Under the CFT watch, under the Dutch watch, under the government of the Netherlands watch, via the CFT, we are 1.4 billion guilders in debt. They're not addressing that. That is not being looked at under their watch. That's a colossal failure. It's a colossal failure. And now you're going to bump up the coho and the CFT with steroids to make it even worse. No. It's not that we have to build back better after a hurricane, because that's the assumption, as if we don't know how to build or we haven't been building better. No, it's because hurricanes have become much more stronger, much more furious, much more disastrous, much more bigger. And why is that? Why is that? Not because of us in a small society, but because of you and your carbon emissions, because of the lifestyle that you are living, because of China producing everything for you and damaging the economy and damaging the environment and damaging the ozone because of their carbon emissions, that Europe is struggling today to sign in the Oslo Accord, Paris Accord. They are struggling to admit that that's what it is. And who suffers that? We suffers that. We feels that because of your carbon emissions. We don't produce the things that is being asked by them. We don't do it. We don't do it. And yes, agriculture where? Roads where? And when we try to sustain ourselves, the tool is used. You can't borrow. You must borrow from me. When we try to float the bond, you use scare tactics. And all our entities pull out and can't for us not to sustain ourselves. So what I'm saying to you, Honorable Professor, through the chair lady, you got to take that message back. And it's the same message that's going to go into IPCO. If you don't hold our hands and cross that threshold to assist and help and make us better by listening, talking, negotiating what is best for us, not what you assume, but what is best for us, for our generation and the next generation. With a debt of 1.4 billion, we are saddling the next generation and the other one to come with debt. No growth. You know what that is? And these are the words that the Dutch don't like to hear. That's called Auschwitz. It's a concentration camp for death. That's what it is. That's what it is. Our economy didn't halt it or collapse because of any fault of us. No. One natural disaster. And I would want to assume a man-made one, if you call the pandemic what it is. We didn't create that. But we don't have the businesses, we don't have the industries, we don't have the companies. And why do I speak this way? Everything in this country that we use to maintain ourselves, a halt was put on it. A 12.5% was demanded for liquidity. A cut in the income of civil servants and entities was demanded. I just heard Prime Minister Rutte, Madam Chair, through you, because of inflation and all that's happening in the Netherlands, they have to raise salaries. Van Hoffelen came here and said, as long as you still need liquidity, the cuts remain. So how is it in one part of the kingdom things can be increased and better for them, and in the other part where you look down on us and say, maintain the cuts? Police officers, teachers, workers, hurting because of not being able to get their vacation pay, can't get their bonuses, can't get their increases because of a law that was forced on us for liquidity. For liquidity. So how it is that we can be in the same kingdom and everything that represents Dutch in this country don't have to take the 12.5% cuts that was passed in the law. It doesn't apply to them. It doesn't apply to them. And the answer and the solution is a coho. Madam Chair, is a coho. How is it possible that in this day and age, the Dutch government, the Dutch entity, can still think that their whipping tool is an entity grounded in laws that we that we can't get out from. That we can't get out from. In the laws of the CFT, if you maintain 3 balanced budget, the CFT ceased to exist. We had 2 balanced budget, and then a hurricane came. And then a hurricane came. We had no choice whatsoever, but to go into a deficit budget. Was there a discussion? Yes. What was the response? No, you can't do it. No, you can't do it. To sustain ourselves. Now, I am not saying that St. Martin doesn't have faults, but for crying out loud, we are 12 years old. 12 years old. And we are reminded of things that we should have done, that we should do, that we need to get done, that took you 374 years to do. But yet we are in the same kingdom. But yet we are supposed to be Dutch citizens. There's a difference. And that difference comes from your end, not from others. And that's why I said I am not entertaining nothing whatsoever called a coho. If the Dutch government doesn't realize in this day and age, the best thing to do is sit down with the countries and have a discussion. An election will come in this country. It will come. And I can guarantee you, the discussion is not going to be, let us go along because our backs are against the wall. It's not going to happen. And what is it? The revolving table all around again? Do this or else? It can't be, Madam Chair, to the Honorable Professor. It simply cannot be. Decisions we are making here is the next generation will have to live with it. The next generation. So we can disguise it. We can take the pig, we can put a bow on it, a ribbon on it, but at the end of it, it is still a pig. Still a pig. And that's why I say I am deeply, deeply disappointed. Because whenever I read it, whenever I look at it, when I hear it, the coho, it is resemblance of the Jim Crow laws and apartheid. It's a separation. Because what's in that and what that is not happening in no other part of the kingdom. No other part. I thank you very much, Madam Chair.
Thank you, MP Emanuel. I don't know if you want to comment on MP Emanuel's statement, or should we move on to the next? Yes?
First
Professor
of all,
Hookers?
thank you, Madam Chair. First of all, thank you, and I feel that you spoke from your heart. So thank you for that. There is a lot that's not very suited to react on, but let me try to go into what I feel is one of the central points you were trying to make when you were discussing this us and them, right? I've often wondered whether this is not one of the unwanted but perhaps unavoidable consequences of a choice, one that we discussed yesterday, the coming into existence of the Charter and how and why that happened. And one of the central choices then made was that, yes, there is one uniform nationality, but there is not, in the political, culturally speaking, historically speaking, but also not in the political sense of the word, one people. I always find it very interesting that quite recently, in the 1990s, the Kingdom Act on the oath of office of the king was amended. It used to be, the oath of office used to be an oath or a promise, but so far all our kings have sworn the oath. It used to be an oath to the Constitution and the people of the Netherlands. It is now an oath to the Charter and the Constitution and the peoples of the kingdom. The king sort of swears allegiance not to the Dutch people, but to the peoples of the kingdom, thereby making clear that apparently, although we all share the Dutch nationality, we are not one people. There is a people of the Netherlands, a people of Aruba, a people of Curacao, and a people of St. Martin. That is mirrored in the fact that we have separate elections. The Constitution of the Netherlands says that the Staten-Generaal represent the entire Dutch people. You might wonder if that's everybody with a Dutch passport, but it's not, because the St. Martin Constitution says that the Staten represent the people of St. Martin. So apparently there are different people again. You can ponder endlessly whether that was a wise choice, whether it was wise to organize democracy within the kingdom along the lines of now 4 separate people represented by 4 different parliaments, where these 4 separate people share the same nationality. Because it sort of suggests that that nationality doesn't mean all that much, and this was one of the central features of the dissertation my esteemed colleague Gohar Karapetian defended in 2020 that she wrote under my supervision, where she analyzed the meaning of the uniform nationality in the kingdom in comparison to France and the European Union, and came to the conclusion that there is a huge difference between what France does with its nationality and what we do in the kingdom. I sometimes, and I wrote that down in a couple of articles I wrote, I sometimes analyze that the way the kingdom is organized, sometimes it almost seems that the charter is aimed at putting it with our backs to each other. There are all kinds of instruments for cooperation, but essentially speaking, the charter was meant as a document to liberate the Dutch colonies from the Netherlands and let me put this candidly, to liberate the Netherlands from its colonies. That was intended in a way, because autonomy and the kind of far-reaching autonomy that the Charter envisioned in 1945 inevitably entails something like that, is a document that is aimed at, well, setting the former Dutch colonies on their own feet, so to speak. Whether that succeeded, now that's a completely different kind of discussion, but that was basically the fundamental structure of it, setting the Dutch colonies upon their own feet, and thereby allowing the Netherlands to go its own way as well, where this kingdom legal order was and is somewhat of a minimum order. I don't know of any other country in the world where the nationals of that country share the same nationality, yet do not elect one central parliament, yet do not have free traveling and settling down rights in the entire kingdom, where the Netherlands so far have decided to not enact that power, but according to the Charter, we could make regulations that would, limit the entrance of Dutch nationals from the Caribbean parts to the Netherlands. That is, under the Charter, that is allowed. The same sort of rules Aruba, Curacao, St. Martin have made to regulate the entrance of Dutch nationals from Europe to the territory of their parts of the kingdom. I don't know of any other country in the world that has a system like that. But it's a system we work with. Yes, one nationality, but if you will, 4 peoples, 4 parliaments, 4 elections, 4 different democratic legitimacy structures, therefore. You can seriously debate in retrospect whether that was a wise choice in 1945, 54. But it's the choice we made, and unless together we choose to completely amend that and to go in the direction of, let's say, the French system or complete independence, but as long as under the present charter the 4 of us remain in this peculiar halfway house between being one state and being 4 independent countries who happen to work together in certain features, which is also a possible, but the charter does neither. The charter leaves us in sort of a halfway house between these 2 solutions. As long as we do that, some of the things you mentioned and some of the things you, and perhaps rightly so, were very, well, very, but were kind of emotional about just yet in your presentation, I feel perhaps are inevitable because they are given with the structure of the kingdom. And, well, that's, Madam Chair, if you will, what I would want to add.
Thank you, Professor Hochers. I see last on the speakers list, we have MP Rayan Peterson. You have the floor.
Thank you, Madam Chair. A good afternoon to Professor to the griffier and Secretariat and everybody else tuning in. It's been a long discussion, so I won't keep everybody here too long. I think enough has been said on the topic. However, I did want your opinion on something, Professor, and that's something that you mentioned in regards to the COHO, but I kind of want to take it a little bit further. Within the newly proposed COHO law, at certain points you can read "naar het oordeel van," which would basically mean to the humble opinion of. Let's translate it like that. You mentioned that when the Prime Minister, the Minister van Algemene Zaken, is mentioned in regards to St. Martin or any country, for example, when either the COHO or the Minister of Basic has to either consult or has to reach a point of consent with our minister, that is something that we ourselves can regulate as to when our Prime Minister can give consent to the Minister of Basic or to the COHO. To that extent, I wanted to take it a step further because, of course, the consensus law, it came about through Article 38 of the Charter, which gives us the possibility to make a consensus rijkswet. There has been a discussion, an ongoing discussion as to what really entails consensus and to what extent we, as the people's representative, as Parliament, have anything to do with that. Currently, and of course, remembering my kingdom law courses, we do not. But to that extent, I wanted to know your opinion as to how would you feel if we, for example, tried to, well, we were of the opinion that we would want to regulate that locally in a national ordinance, which would mean, and if the Prime Minister goes into dealings with the kingdom government in regards to what a proposed kingdom law, that should be a consensus, that consensus cannot will be established if a process with Parliament does not happen first. I don't see within the Charter that is not allowed to be regulated. And so I was wondering, what is your opinion on that? Because at the moment, I think that within Parliament, the sentiment is that the COHO cannot pass. As it is, it's infringing on our autonomy. I think all of us are basically on the same boat when it comes to that. But we did have a meeting with the Prime Minister and her cabinet last week, and the impression that I have is that from their side, it's a go. It's still a go. Regardless of Parliament's grievances with it, regardless of the meetings that we as Parliament have had, our public statements, the separation between us and government, to my opinion, might cause the friction between. So to that extent, I go back to the question because the consensus at this point, it is clear that a consensus from the government of St. Martin does not include a consensus from the representatives of the people of St. Martin, which is Parliament. What would be the best way to tie that in? Because this would avoid us, let's say, future discussions, because the Prime Minister would not be sitting there proposing a COHO to us while we are here hammering on her as if she is the one who's proposing it, because she would not have been able to give that consensus in the first place when it comes to the initial discussions with the Kingdom government. So just your take as to how you feel on that. Thank you, Madam Chair.
Thank you, MP Peterson. And MP Peterson, since you're the last speaker, you took my question is exactly close to that. So I'm just going to add a little more meat and potato to the question before you answer, Professor Hochers. Take, for the public, for the viewing and the listening public, explain to everyone how the trajectory will go from now. So if Parliament decides today, we gave in our verslag, and then what's next? Do we table a motion saying that we're for, against, or we want to make amendments to that? And if, let's say, for instance, it is no, our motion says no to the COHO, what happens then? Explain everyone the trajectory and what it entails right now. Thank you, Professor.
Thank you, Madam Chair, and thank you, Member of Parliament Peterson, for your very interesting and very insightful question, because this is important. Well, you could argue everything is, but this is important at least as well. One of the strange things of the Charter, and there are many strange things about the Charter, but one of the strange things about the Charter is that it contains a provision that is, in my, at least as far as I know, also unique in the world, where the constituent parts of the kingdom, the countries, can decide amongst themselves to regulate matters that are within their autonomous sphere of capacity through the kingdom legislator. As far as I know, there is no other example in the world where that is possible. If Texas and Alabama and Georgia want to regulate something, they cannot do that through act of Congress. That's just not possible because, well, Congress acts on behalf of the United States, whereas the state legislators act on behalf of the states. If Bavaria, Saxony, and Bremen wants to regulate something together, they cannot do that through a Bundesgesetz, through a federal act of the German legislator. But in the kingdom we can. For a long time, that procedure has been scarcely ever used. And in his important study on the coming into existence of the Charter, Van Helsingen writes in 1955 that probably this procedure is not going to be used very often. And for a long time that was true. And because that procedure was never used, we never had to think about how do we do that exactly. Because the strange thing, of course, is that such an act dealing with an autonomous matter of the countries, it's very hard to see how the ordinary legislative procedure that the Charter provides for could be applicable. Because that procedure is a procedure in which the Caribbean countries can be overruled by the Dutch representatives in the kingdom organs. Now, it is very hard to assume, very difficult to assume, how that would be possible for a matter that is an autonomous matter of the countries. It would mean that a country, in deciding together with one or more other countries to regulate the matter through a kingdom act, automatically uses its autonomy in that field. Van Helsingen still assumes that in 1955, and he goes on by saying, so therefore this procedure is probably never going to be used. Because why would a Caribbean country do that? It's probably, if it's ever going to be used, then probably only for very unimportant technical matters. And like I said, for a long time, he was right. The only thing the Charter has to say about this, in Article 38 under 2, is that the governments of the countries have to agree upon it. About what exactly? The article is not clear. Is it agreement to do it through a Kingdom Act, or is it also agreement on the contents of that Kingdom Act? The article itself is unclear on that. The official explanatory notes on the Charter are unclear on that. The beginning of the 1990s, former then Minister of Antillean Affairs Hirsch Ballin proposed the term consensusrijkswet for such a Kingdom Act. That term is not in the Charter, but it stuck because it sort of describes what it's supposed to be, a Kingdom Act based upon consensus between the partners. Since then, it has become, pun intended, more or less consensual among the kingdom partners, that consensus means consensus on the contents of the act, which makes perfect sense because it's an autonomous matter. But that's basically where the problems start. Okay, how do you measure such a consensus? All you have, based upon the Charter, is the procedure for making a Kingdom Act. What you basically then have to do is, in all the different stages of the Kingdom Act procedure laid down in the Constitution of the Netherlands and the Charter, is to look at these different stages and then constantly ask yourself, how is this procedure to be used from the point of view that there should be consensus? You could, for instance, argue that the whole procedure of Article 12 in the Council of Ministers of the Kingdom cannot be used in that way. It's impossible to assume that the Minister Plenipotentiary can be overruled in a consensus Kingdom Act. So, presumably, as soon as the government of one of the countries instructs the Minister Plenipotentiary to be against this, then there is no consensus, and then the law proposal cannot move on. Then first you have to renegotiate again. If you go on to the parliaments, things become even more interesting. Because, again, all the Charter says is there has to be agreement among the governments. Now, there are two possible different opinions. You could argue, and it's for a long time, it is what has been argued by most scholars and also by the Council of State, that because the Charter talks about the kingdoms, talks about the governments, that means that there should only be consensus among the governments. And as soon as that consensus is reached, well then, consensus is meant in Article 38 is reached. I've always resisted that point of view. I've always said, and you remember that from my classes probably, I've always said that that approach makes no sense. At least it makes no sense when you're dealing with a subject matter that, according to the constitution of the country involved, is a subject matter for the legislator. As soon as that is the case, in my opinion, it makes no sense to assume that consensus should be only the government. Because when you would regulate said matter through a national ordinance, you would need the consent of Parliament. If you regulate that same matter through a Kingdom Act, and then assume that Parliament should play no role in it, from my legal point of view, that makes no sense. For a long time, I was quite alone in this. And as a lone purveyor of an ancient truth, I kept on my vigil. And lo and behold, recently people have started moving in my direction. I found it very interesting that, as far as I know, for the first time ever, in this trajectory, the Coho trajectory, the Dutch government for the first time has officially acknowledged that this cannot be done without the consent of the three parliaments. I would agree. And I was discussing this very same topic with Juan Thijssen from Aruba, the former chairman of the Aruban parliament, who is now he's not the minister plenipotentiary, but the second in the lieutenant minister plenipotentiary, exactly, yes, that's how you say that. Plaatsvervangend gevolmachtigde minister. I discussed this with him in the Aruba house a couple of weeks ago, and I said to him, this must be noted. This is important, and you should not let this go. Also for future references, because when it's true this time, it is true any other time. So I would argue that yes, consensus would mean for the Rijkswet Coho, but for any other future consensus Rijkswet pertaining a matter of the legislator under the constitution of one of the three Caribbean states, the three Caribbean countries, consensus means also the consent of Parliament. Now, how is that to be made clear, made present, that consensus? There are different procedures of which you could think. One of them could be to pass a motion, in which Parliament says, we are in agreement with this law proposal, or we are not in agreement with this law proposal. We are not going to accept this law as it stands. Now, such a motion binds Parliament. It doesn't bind the government, but that's not necessary, because Parliament, in doing so, binds itself, and the consent of Parliament is necessary. Now, if Parliament explicitly states there is no consensus, then there is no consensus. So that's one possibility. Of course, it's also, I would argue, and I would be in agreement with you, Mr. Peterson, in this, that if you say, is there anything in the Charter, or for that matter, in the Constitution of St. Martin, preventing passing a national ordinance in which you say, look, in certain important matters laid down in this national ordinance, the government cannot act without the previous consent of Parliament? Yes, I would argue such a national ordinance can be passed. Yes, it would be an organieke landsverordening, I would say. An organic national ordinance in which yes, of course, such a national ordinance would have to be signed and approved by the government as well. But yes, you could do that. But you could also put it in your own rules of procedure of the Staten themselves. That those are only binding on the Staten, of course, they don't bind government, but they bind you. And, well, if you are not willing to pass any legislation that government has agreed upon, then you can look at your own rules of procedure and say, look, government, you should know that we have said, it's the same logic that is used now in the Netherlands. The second chamber has put in its own rules of procedure that no government can be formed without the active participation and the guidance of the second chamber. Now, obviously, that doesn't bind the king, but no government in the Netherlands has been formed since this has passed without the guidance, the direction, and the serious involvement of the second chamber in 2012. We have no longer an informateur nominated by the king. The informateur is nominated by the second chamber. And that is based upon the rules of procedure of the second chamber themselves. So technically they only bind the second chamber, but they have, of course, that works outside as well. So that would also be a possibility. Which also possible, in my opinion, would be that when the Rijkswet Coho is going to be passed and handled in the Dutch Parliament, you can send, as you know, special representatives based upon Article 16 and 17 of the Charter. If they would formally declare during the handling of the law proposal in The Hague that the St. Maarten Parliament is not in agreement with this law proposal, then I would argue that's also a very clear way in which the lack of consensus is shown. And that would be a relevant statement, in my opinion. That would mean that for St. Maarten, the consensus is lacking from one of the two relevant partners, namely the government and the parliament, because they both should be in agreement. And since the Dutch government has now officially acknowledged that the consensus of the parliaments is needed, that will be a politically relevant fact for the Dutch as well.
Claire? Yes? Thank you, Professor Hoogers. One last question, because everyone had, but one last question before we go. You stated earlier that the Coho is a Dutch organ, it's a Dutch law. Now, wouldn't that clearly state that they're infringing on the country's democracy when you create a law in Holland to oversee? Yes?
I understand your point. You have to differentiate between two things. The law itself is a kingdom act, is a consensus kingdom act that needs the approval of the four countries. The organ created through that act is going to be a Dutch organ under Dutch law. Yes. So that's the difference. And you could perfectly argue that that is a problem, but you should differentiate between these two positions. The law itself is not a Dutch act. The organ is going to be a Dutch organ.
Thank you, Professor. And Professor, I see that I guess we have come to the ending of this deliberation, and we would like to thank you for all the information, all the answers, and all your position as well, on some very strong, on the Coho. Ladies and gentlemen, we have come to the end of this part of the meeting, and this meeting will then be adjourned until Friday, on April 22nd, 2002, when we will continue, 2022, I said? Oh, I said it this time, right? Yes. When we will continue this meeting with our former Lieutenant Governor, Mr. Dennis Richardson, and an attorney at law, Ms. Natalie Tacklin. I would like to thank everyone for your participation, and I hereby adjourn this meeting until Friday. Meeting adjourned.